Good morning. My name is Starla Leverett, General Counsel of the Alabama Real Estate Commission. And today we're going to be looking forward to what is new in license law, what is proposed to be new in license law, new issues leading to license law violations, and some new pitfalls that we need to be aware of. I want this to be as interactive as possible, so if you have a question, please hit your raised hand icon and we will unmute your mic and then mute it back. So the first thing I want to talk about is a new rules package that actually goes into effect tomorrow. There's two parts of it that will be in effect April 14th, but the majority of them will be effective tomorrow. Happy Valentine's Day with these new rules. I just want to go over a couple of them just so they're on your radar. And these can all be found on our website as well. If you go to our website, you can actually see the rules that were proposed, and there's actually a link that can send you to the text of the rules as well. The first one is regarding co-brokerage agreements. We just further defined that when we say the word broker in a co-brokerage agreement, you have to be the qualifying broker. It's not someone that just has a broker's license but not a qualifying broker. So you have to be a qualifying broker to enter into the co-brokerage agreement, and the person from the other state also needs to be a qualifying broker as well. Another one I want to touch on is that we do allow nicknames to be used, but we want to make certain that when using your nickname, like if I'm going to go by Star, I still have to use my surname when I do my advertising. So instead of just putting Star on the sign, it still needs to be Star Leverett so we can identify you on the alias. The next one I'm going to talk about is that we have stricken the language that you have to keep all files at your place of business. It's just kind of catching up with the times. They obviously can be kept in an electronic format, and most of the audits we do now are just done virtually as well. Another thing I want to talk about is one of your favorite topics, estimated closing statements. We just further defined and just made it very clear that there has to be an estimated closing statement prepared for every offer and every counter offer on both sides of the deal. So this just makes that, the rule kind of cleans that up and makes it very clear on that. The last one I want to touch on that's going to be effective tomorrow is the advertising one. This is basically, we have taken the word prominent, which is used in our current law that says the brokerage name has to be prominent on any advertising. And we further defined what that means. And it simply means that the salesperson's name cannot be bigger than the brokerage. Equal, they just have to be equal. It's very easy. Obviously, we'll give some grace time to this so people can fix anything they have out there right now. But from now on, the broker's name has to be the same size or larger than the salesperson or team name. Like I said, two of these will go into effect in April. I just want to touch on one of them that'll go into effect in April, and this has to do with mutual releases. And again, we've just clarified the law as it is and further defined that a mutual release can only be entered into after the transaction fails. This is not something that can be done prior to that or written into the contract. It only can be done after the transaction fails, and that's when you can enter into a mutual release of the earnest money. So those are the rules. There are a few more, but I just kind of want to touch on a few of them. And again, you can go to our website and look at these yourself. Does anyone have any questions on the rules? Okay, with none, I want to move on to what has been some legislation that has been introduced. It's House Bill 225. And it's sponsored by Representative Rolanda Hollis. And so I want to touch on this, kind of the bulk of it. It's basically an educational bill. So there's a lot in there about schools and different things like that. I wanted to touch on kind of the two bigger topics in this because it is a shift, a large shift in how people become licensed and how people will become a qualifying broker. So right now, as you all well know, because you're licensed, you have a pre-license, then you take the exam, and then you do post-license. And after you take that exam, you get a temporary salesperson's license, and then you do the post-license, and then you move on to your original salesperson's license. This bill does away with post-license. Instead, we're going to have a pre-license 1 and a pre-license 2. So the pre-license 1 is going to be exactly how it is now. It's the 60-hour course. You take it, and then you take the state test. This is really focused on getting you the information you need to actually pass that test. So it focuses a lot on license law and just that knowledge you need to pass the test. Once you pass that test, instead of getting a temporary license, you will then take a second course called Pre-License 2, and this is going to be a 45-hour course. contract, things that you need to know to actually go out there into the workforce. And I just kind of want to give you a little bit of background on why this bill is doing what I'm proposing it to do. It's simply that when talking to the licensees community all over the state of Alabama, one of the most common themes we heard is you really want to raise kind of the professionalism in this industry. And raising the education to get into the industry is one of the ways to do that. Just preparing you that when you go out there to work your first deal, you actually do know how to write a contract. And we've heard stories from all over the state of people who don't know how to write a contract, and their broker really can't help them write a contract. And so they're asking the person on the other side of the deal, maybe the listing agent that's been in the business for 30 or 40 years, hey, help me write this contract for my buyer. So we want to make sure when you get out there and you're actually a practitioner in real estate that you're prepared and that it helps kind of raise the bar for the entire industry. So you're going to take that second pre-license 2, 45 hours. At that point, you can then apply for your temporary salesperson's license. So at that point, you go to work for a brokerage. After that, when you start working for the brokerage, you then would have to kind of choose, where do I think I'm going to land in real estate? Do I want to do land deals, commercial, residential, property management? And once you make that decision, you then would be required to take a 15-hour course that focuses specifically on that part of real estate. So let's say that I want to do land. I would take a 15-hour class on land, and I would learn even more of the day-to-day. How do I actually do this? It's easy to learn. I mean, I went to law school, and you get all this knowledge. But the first time you walk into a courtroom, you are scared to death. You don't know what you're doing, and you have to kind of learn on the job. So this is, again, preparing you for that. Now, obviously, if 3 years from now, I'm tired of land, I want to go sit in a pretty house where it's air conditioned, you wouldn't have to come back and take another 15-hour course. It's just kind of that initial time. So you have to take the 15-hour course. And then another thing we're going to do is your qualifying broker then would have to check off a core competencies checklist for you, just to say, yes, this person knows the basics of how to be a practitioner in real estate. They know how to write a contract. They know, who's the Alabama Real Estate Commission, things like that. So that's going to be a little bit different. Well, it's not a little bit different, let's be honest. It's a lot different than the way it is now. So that's part of this House bill. Another part of it is how you become a qualifying broker. So as you all well know, currently in Alabama, you would become a broker after 2 years, you can apply for your broker's license. And then immediately, once you get that, you can become a qualifying broker. Well, the problem with that currently is we might have someone that actually never has had one transaction, and yet they want to become a qualifying broker. This is the person that's leading the entire team. They're leading all of the salespersons. So we want to make sure they know what they're doing. So still, after 2 years, you can apply to be a broker, but then you have to serve 2 more years as an associate broker. So that's just kind of building a little bit more time under a person's belt until they're out there leading their own brokerage. Another thing with this is that you would have to take a course prescribed by the commission that basically talks about what you need to know to be a qualifying broker. And this would, again, prepare you for what is expected of you as a qualifying broker. So that's another portion of this bill, and it is a change, but we think it's a change that's going to lead to, and I know if you're watching this, you're the people that do it right because you tuned into this, but you don't hear the stories we hear where people don't even know the name of their qualifying broker. That's how out of touch some people are, and they're supposed to be the ones responsible for everything. So that's another big change in this House bill. And I think I have a question, so let me pause for a minute. I know this is a lot of information coming at you. Yes. Tamara, you have a question. Or Tamara, can you unmute your mic, please?
Okay, thank you.
Absolutely.
I was trying to figure out how to unmute myself. Okay, so my question is in reference to the 15 hours, who provides that 15 hours, or if it's land or if it's property management, is it the qualifying broker's responsibility to create a class, or will the commission have classes or some online resource for them to take those classes?
That's going to be that's a great question, and that's going to be a commission developed course.
Okay, thank you.
The qualifying broker does not have to worry about developing that course. That will be developed by the commission.
Okay, thank you.
You're welcome. Any other questions right now? All right, while we're waiting on that to work out, there's one other part of the bill I want to talk about, and that is a section where we're actually removing a violation from license law. So you all will know that there's a violation that if you basically call it the bad check. If you send a bad check to pay your license renewal fees or for a fine or for anything, it's a violation of license law. And this is the most violated violation in license law. So we're trying to move past it because the majority of these are not what you think of, like someone sends us a check and they don't have the money in the bank. Most of these actually come from when you pay on Alabama Interactive and someone does one wrong digit in the account. And I think the majority of these, no one is meaning to do this. It just happens. So we want to take this out of the violation section, and instead it'll simply be that you do your license renewal. Let's say a mistake is made. We get notice that they're unable to locate that account. As long as you get us the money within 30 days, then it's no harm, no foul. We all move on. However, if the money is not given to us by the 30th day, then the license will lapse. And it's simply that at that point, you have a license that you didn't pay for when everyone else had to pay for it. Excuse me. So that is what's going to happen with that portion. And I think I had a question.
Can you hear me?
Yes, I can.
So I don't have a question. I just wanted to say how absolutely fabulous it is to hear all this. Thank you, thank you, thank you. This should be done across many states to raise our industry. Love to hear it. Thank you very much.
Thank you. We appreciate that.
Can I ask a question now? Can you hear me?
Yes, sir. I can hear you, Mr. Blackburn.
I apologize. It took me a
It's
while
okay.
to figure that out. I actually have two questions. Going back to your first, your opening statements about the mutual release can't happen until after a transaction fails. Can you define when failure occurs? If a party were to say, "Hey, I am out," at that point, is that a transaction has failed?
Correct. Yes, sir.
Okay. Thank you. My second question is going back to the specialty, which is extraordinarily exciting to many of us. When you pick a specialty and when you do the 15-hour course, are you limited to that niche of real estate?
Absolutely not. And it's not going to result in a special license like some states have. Like some states have a property management license. This will still be a general license as we've had in the state of Alabama. It's just a little bit further education. It's, especially in things like property management, there are so many nuances in that you need to understand that a lot of people don't when they get into property management. Same thing with land. So it's just to kind of help further elevate the person's knowledge before they're out there practicing real estate. But you are not tied to that specific nuanced area at all.
If I may, just one last question, please.
Absolutely.
The estimated net sheets to date, they have been residential. Yeah, and I don't know if I heard you right or not, but are they now required for commercial and land sales as well?
No, absolutely. Excellent question. And I should have pointed that out. They are still only required for single family residential sales.
Okay, thank you. I think I'm done for now.
Okay, if you have more, just raise your hand again. I think I have another question from Pamela.
Hi there, can you hear me?
I can hear you. Yes, ma'am.
Good morning, everyone. Yeah, I love what is being said this morning. But my question is about the 15-hour course. If you're fairly new, will you be able to take this course if you've already gotten your license? This is something that you can come into later on and take it. And
yes, you can.
Will there be a fee for this as well?
Pamela, I do not know the answer to that, but I will get back to you on that. I don't know, but you can absolutely, like if I had been in the industry for a few years and I just felt like, hey, I might want to move over to property management or something else, the class will be that will be open to anyone that wants to take it. But regarding the fee, if I think we can see her last name. I'll get back to you on that. Okay.
Okay, one last question. When is this going to start?
So this is that portion that I've just talked about. All of this has been introduced, legislation that's been introduced. I believe it was introduced last week. So this is something that still has to go through the legislature. So in saying that, I've heard some very positive responses from you guys, which is awesome. If you like what I've been talking about, you need to reach out to your elected officials who are in session right now and tell them that you want House Bill 225 to move forward. That is what they need to hear from you, because it's arrogant of me to sit here and say this is what should happen out there. You guys are the practitioners, I'm not. So if you guys like it, and again, this legislation is on our website, so please feel free to go and read through all of it, because I'm just kind of hitting some highlight points. But once you read through it, if you like it, reach out. That's the only way we're going to get this passed, is for you to reach out to people and say, hey, this bill 225, we think it's good for our industry. So right now there's no set date. When it does pass, it'll be effective at different times, and those times are going to be depending on how much time we need to implement things. And when you look at the proposed legislation, you will see different effective dates in there. The rules that I talked about earlier, they're tomorrow morning, but this is something that's not going to be effective for maybe another year, 6 months, or even 2 years down the road. Any other questions right now?
There, it popped up. Good
I
morning.
gotcha. Good morning.
This is a property management question and has to do with the short-term vacation rental. And I know there's been some talk about the commission making some determinations on licensees that are setting up as co-hosts, especially through Airbnb, and doing full services and not running it through a brokerage. I was just wanting to see kind of where the headway was happening on that.
Well, this is a very, especially down in South Alabama, this is a hot topic. We get a lot of complaints from people who are acting as a host or a super host of these properties who are not the owners. So it's basically we have a third party. So what we've done thus far on this issue is we drafted kind of a policy that the commissioners approved, that of things we think are acceptable for a host to do. Like, can the host go in and, afterwards and clean up? Yes. Can they get the parking tickets? Yes. Can they get if there needs to be some kind of pet situation, they can take care of that. This is a very difficult thing because ultimately it's hard to prove what the host is actually, doing. Any licensed activity they absolutely cannot do. And regarding someone that's doing it on the side, unless they own the property, that still has to flow through their brokerage. That's the only, if you own property, we do have a provision in rule that if your broker allows it, you can treat that separately. There's some rules that go along with that, and we passed those 2 years ago. But if it's something that they don't own and they're doing it, like if I had some, condos at the beach and they're doing it for me, that still has to run through their brokerage. Absolutely. Does that answer your question, Tim?
Yeah, it does. I've just noticed that there's been they'll have the owner go set up as the host, and then they'll put themselves as a co-host. And the only reason I know that because we've managed properties and the people have left the program, and they had no intention of wanting to even do it at all. And then we see a new person line up as the co-host. So you could pretty well read between the lines that full service is being offered besides just cleaning or maintenance.
You're right, and it's hard to do this. I mean, I volunteered to kind of go undercover and sign up and go to these places and see what's actually being provided by who, but I was shut down on that. So it's a hard thing to figure out, but we're trying our best to navigate. I mean, some states have gone to, I think Nevada, some states have gone to the fact that if it's less than 30 days, you don't need a license. And obviously we don't want to go there because property management is huge in our state, especially down at the beach. So we're trying to navigate through it as people find a way around rules all the time.
Absolutely. Okay, thank you.
All right. Any other questions right now? Okay, I want to move on. So we've talked about the rules coming into effect tomorrow or in April. We've talked about the proposed legislation, House Bill 225. I want to kind of focus on a couple of things. Actually, it's just one thing that's popped up, and I've been here for 5.5 years, and I've not had this. And in the last 3 months, we've had 3 cases go before the commission on this issue. When you are dealing, so it's just like this is a cautionary tale. So it's just a new thing. When you are dealing with people that are divorced, going through a divorce or recently divorced, and you sign on as a listing, whatever side you're on, please take extra time to make sure that you know who the rightful owner is. And if it's the 2 of them, they both need to be told, given information and be in the loop of what's happening. Like I said, we've had 2 cases go in front of the commission where they only decided to speak to one of the parties, and actually both parties were on the deed. So it's just something that I think, and we had actually another one come in last week, just make certain that you're taking that extra time to make sure that you know who you're supposed to be dealing with and who's on the deed to that property. Okay, I think we have another question. Tim Veer, I don't know how to say it. Veerkant. Can you please unmute your mic? Okay, I'm gonna move forward, but if you unmute and I hear your voice, I'll stop talking. Another thing I just want to that's new, and hopefully none of you have experienced this, but I want you to know it's out there. We are having a lot of phone calls on scams happening with land sales. And this is happening when basically, because it's land, there's no one living there, so that's easier to do. You have the owners saying that they want to sell it. They get in touch with a licensee. They might even provide, ID. It's fake. It's forged, other things like that. And the licensee, then finds a buyer and they do a sale. And in fact, these were never the owners of the property. We had one that happened a couple months ago where it was a cash deal, $300,000. And it ended up that it was a complete scam. The money was sent and that land was never for sale. So just make sure that if you're dealing with a land sale, it's just someone you don't know. If you can do any digging at all to try to figure out, make sure this is the real owner. We actually had one licensee that found a deed with an owner's name and actually went to that person's house and knocked on the door and said, "Are you selling this land?" And the lady's like, "No, that's not me." So just be cautious that is out there. And just, be cognizant of it and just do as much, there's only so much you can do when people are providing fake documents and fake IDs, but that's just something that we want you to be aware of. And finally, I just want to sign out on something that's not new in license law. I don't know why we've had an uptick in phone calls on this. We actually had someone come to the office yesterday regarding this. You still have to have a brick and mortar building in the state of Alabama if you have a licensed company here. So when you hear the word virtual office, those are still not something. You can have a virtual office. There's no problem with that. You can work out of Starbucks. You can work out of Chick-fil-A. But there still has to be, for a licensed company, a brick and mortar location. That has not changed. That is not expected to change anytime soon. So I just wanted to say that is something that's not new. We have not moved to no brick and mortars yet. Any other questions before I start ending this? No? Okay. All right. Well, I just want to thank you again for tuning into Briefly Legal. Please tune in for our next one, which is May 1st. And always remember that you can reach out to us. Our phone number is 334-242-5544. Our email is arec.alabama.gov. Our website is arc.alabama.gov. Remember, you can find us on social media. We're on Facebook, X, Instagram, YouTube, and our social media handle is @ARC.AlabamaGov. And I say this all the time, but please remember that we always send important information via email. So please read emails from us. It is important. And again, if you guys have any more questions about the rules or the legislation, you can always call us. You can call the legal division and we'll be happy to talk to you about it. And just a reminder that they are on our website, so you can go there, especially if you're the qualifying broker. It's an excellent tool. Print them out, give them to your people so they have them as well. And anyway, I hope this has been informative. Y'all have a great day and have a very happy Valentine's Day tomorrow.